Okay. Calling docket numbers 2100661, People versus James Crumbley, and docket number 2100662, People versus Jennifer Crumbley. Can I have appearances on the record, starting with the prosecutor first, please?
Karen McDonald on behalf of the people.
Thank you. Mark Keast on behalf of the people.
Good afternoon, Your Honor. Marielle Lehman on behalf of James and Jennifer Crumbley.
And good afternoon, Your Honor. I'm Shannon Smith on behalf of James and Jennifer Crumbley. Today is the date and time set for the defendant's motion to amend bond. The court is hearing this motion by Zoom. Both defendants are at the Oakland County Jail and are appearing by Zoom, as are their attorneys and the prosecutor. Any objection to appearing by Zoom, prosecutor?
No, Your Honor.
Defense counsels?
None, Your Honor.
No, Your Honor. Again, this is the defendant's motion to amend a bond. Keep in mind that the court has had the opportunity to review both the motion and the prosecutor's response. Go ahead with any oral argument, and please try not to repeat anything that's already contained in your pleadings that the court did review.
Thank you, Your Honor. As the court is aware, MCF 6.106F provides the criteria for determining an appropriate bond. The defense has filed a motion, which we are aware that the court has reviewed and has read thoroughly. However, there are a number of false, misleading, and irrelevant statements made by the prosecution in its response, which we will address today. First, the information provided by the prosecution related to extramarital relationships is not only clearly irrelevant to the issue of bond or any criminal responsibility, but is also a clear intention by the prosecution to create a conflict between the parties. Your Honor, there is no conflict. We have explained and discussed the matter of extramarital relationships with our clients, and there are no issues. Finally, any evidence or information obtained about extramarital relationships and subsequently used in the prosecution's response runs afoul of the Michigan Supreme Court's holding in People v. Hughes, which is 506 MISH 512. In that case, which is an appeal from an Oakland County jury trial, the Michigan Supreme Court held that any evidence of other crimes discovered during the execution of a search warrant falls outside the scope of the search warrant, and use of that information is effectively a warrantless search and violates the defendant's Fourth Amendment rights. Secondly, Your Honor, in Ethan's journal, which was provided in discovery, he explicitly states, and I quote, that he has to find where his dad hid the firearm. This statement, in Ethan Crumbley's own words, is contrary to the false and misleading assertions that have been made by the prosecution in this case. The assertions that the firearm was freely accessible to Ethan Crumbley. Further, Your Honor, the prosecution cites People v. Head 323 MISH Act 526 and People v. Bryson, which is an unpublished opinion from the Michigan Court of Appeals, as support for their position that they have a strong case against our clients. Both cases, Your Honor, are completely distinguishable from the matter pending before this court. In fact, both cases involve firearms that were stored loaded with ammunition and in a location known to the juvenile. Your Honor, finally, the prosecution references an incident involving torturing animals and Ethan Crumbley keeping a bird head. His parents were completely unaware that Ethan had engaged in any sort of torturous behavior. They had no knowledge of an incident involving a bird head. In fact, again, Your Honor, in Ethan's journal, which was provided in discovery, he makes clear that any such conduct was carried out in the manner in which his parents would not be aware. Your Honor, we filed our motion after we received discovery because there had been a change in circumstances. As we noted in our motion, the prosecution has changed its position, and some of Ms. McDonald's statements have been changed in her media interviews as to the existence of discovery or the existence of statements or the existence of facts in this case. Your Honor, the bond is currently set at $500,000 cash or surety, no 10%. Based on the new information that was provided in discovery that is in the possession of the prosecution and also in our possession, we're asking that the court reconsider bond and reduce the bond to $100,000 cash or surety. We do agree, Your Honor, and would consent to the use of a GPS tether as the court has previously ordered.
Hey, put a lid on it, all right? Or I'm gonna have to work you guys up a little bit. Until you admit
Your Honor, you're on mute.
never the answer, ever. What do we really want?
Ms. Lehman, I assume your argument is as it relates to both defendants. Is that correct?
That's correct, Your Honor.
Okay. Any response from the prosecutor's office, and who is responding?
Yes, Your Honor, I am going to address the issue of flight with regard to bond decisions. Mr. Peace is going to outline the facts of the case. And of course, we absolutely object that we have changed positions, but I'm going to leave that for Mr. Peace to outline. Further, as you know, the underlying, one of the underlying factors here is whether or not defendants are a flight risk. And one of the things to consider for the board, as you know, is ties to the community. The defendant's employment is something that I need to highlight. James Crumbley had employment as a delivery person for DoorDash. That's employment that is entirely discretionary and is up to the actual individual. Jennifer Crumbley's employment has been terminated by her employer since the charges were issued. All of the items in their home are being removed and put into storage. Their home is being placed on the market for sale, according to their own attorneys. Their family members in Florida are negotiating the sale of their horses, which is the only other asset they have. And with regard to ties in the community, there are no longer existing ties in this community, but even more importantly, the only ties these two individuals have, other than their son, who is awaiting trial, is their ties are out of state. Both defendants' families live in Florida. Defendant James Crumbley's other children, his parents and siblings live in Florida. Jennifer Crumbley's father, mother, and brother live in Florida. These family members all have been supporting and handling their affairs. These are some of the same family members who've been arranging their items placed in storage, the sale of their horses, and putting their home up for sale. Finally, with regard to flight, we need to talk about and address what Jennifer and James Crumbley did on November 30th, just hours after their son murdered children in a school. They started making plans. On November 30th at 4:42, defendant Jennifer Crumbley texted the contact she needed to sell her horses staff. Upon information and belief in charges against their bank accounts, they drove to a pier and stayed the night in a hotel. At some point on this date, they also purchased a total of 4 cell phones, 2 of which were duplicate numbers, which were provided to law enforcement, and 2 additional ones were numbers that they did not provide to law enforcement. At an unknown time on that day, additionally, they drained their son's bank account, transferring $3,000 into their own account, leaving him with a balance of 99 cents. On December 1st, at around 9 a.m., they checked into a local hotel in Oakland County, within miles from the Florida court hearing. At 11:23, more contacts were discussed about the sale of the horses for $5,000. On December 2nd, at 9 a.m., a withdrawal of $2,000 was made from their bank account. Text messages and testimony will reveal that the company is expected to be criminally charged the next day. On December 3rd, at 9:30 in the morning, they checked out of that hotel. Before leaving, they abandoned their second car in the back parking lot with a plate facing back. At 10:05, Jennifer Crumbley responded to a text about finalizing the sale of the horses and indicated that they were awaiting charges announced at 12 o'clock. At approximately 10 o'clock, she called Andre Sephora and said they needed someplace to sit while decisions were made. They had nowhere else to go. At 9:16, they withdrew an additional $4,000 in cash from their bank account. They then drove to a location at 1111 Bellevue, Detroit. At 12 noon, the swear to was performed in the report and charges were announced. Once they arrived at this building, they never left the premises except once to smoke, and also when James Crumbley moved their car so that the license plate would not be visible. And at approximately 1:30, they told Andre Sephora that they had been charged criminally. At that point, they requested that he leave the studio and go get provisions for them. They asked for vodka, orange juice, and socks. He also secured a mattress and bedding for them. At 10:47 p.m., opposing counsel texted to the fugitive apprehensive team that we will get them in. They wouldn't have paid us what they paid if they planned to run. At 10:50, officers were dispatched to that location. Once inside in the art studio, they remained in the locked doors, even after multiple law enforcement officials entered the building and announced loudly and repetitively, police. They remained behind the locked door, crouched by a mattress on the floor. Once they were taken into custody, they possessed Jennifer's social security card, more than a dozen credit cards and gift cards, 4 cell phones, $6,600 in cash. And 2 of those cell phones were trapped burner phones, and one they had smashed in an attempt to destroy it. Remember, these are not the actions of individuals who wanted to turn themselves in. They had knowledge of the pending charges based on their text messages. And what did? They didn't go across the street. There was a police station across the street from their hotel. There was nothing that was preventing them from staying right there. They didn't go to the court. They didn't turn themselves in. They fled to another county. And nothing prevented them from staying in Oakland County. Once they left the county, they went to an undisclosed industrial site where they tried to conceal their presence. And once the charges were issued and they were informed, they asked the court to purchase bedding for them along with vodka and orange juice and other food items. Their phones they possessed were unknown numbers to law enforcement, and they purposely concealed themselves and their car. Even up until the last moment, they didn't open the door. They remained behind a closed door and crouched on the corner. And they were apprehended with $6,600 of cash and 10 credit cards. They are a serious risk of life, and we urge you to deny their motion. Mr. Keese will address the issues of likelihood of conviction.
Thank you. Your Honor, defense counsels have alleged that we can't prove our case. Under the court rule under NCR 6.106, they're certainly free to do that. But when they do, we have an obligation to correct the record. Our response provided this court with just a snapshot of what the evidence will show when the examination begins on February the 8th of this year. This case is strong. Defendants will be convicted. Once they're convicted, they will go to prison. They're charged each with 4 counts of involuntary manslaughter. It's important to remember that these counts of involuntary manslaughter are based upon alternative theories. They are not mutually exclusive. They committed these crimes by being grossly negligent in the storage of that firearm or by breaching their duty as parents. The evidence admitted will prove both of these theories. The evidence will show that Ethan Crumbley was gravely troubled. He was fascinated with firearms. He was violent. He displayed terrifying tendencies and behaviors, and he literally sketched out what he planned to do in his journal and his drawings. Even a cursory review of the forensic examination of cell phone seeds showed that the negligence on the part of these defendants and their failure to perform the duties of their parents far preceded November the 30th. The evidence will show that as far back as March of 2021, Ethan Crumbley would text his mother, Jennifer, on more than one occasion, and always when he was home alone, that he thought there was a demon, a ghost, or someone else inside the home. These weren't one-time messages. He would repeatedly text what he was perceiving to his mother, who sometimes would not respond for hours. The evidence recovered from Ethan Crumbley's phone shows that in May of 2021, he was torturing and killing animals. He did this at the family home. He filmed himself doing it. That film was on his phone. Not only did he film those actions, but he kept severed head from a bird that he had tortured and mutilated in a jar in his room for 6 months. The evidence recovered thus far shows that Ethan Crumbley was creating Molotov cocktails at the family residence as well. That phone extraction also revealed that he searched school shootings and firearms so often on his phone that he received spam advertisements regarding his mental well-being and firearms. We have found that Ethan Crumbley was also fascinated with guns and Nazi propaganda. He purchased a Nazi coin from Amazon and kept it in plain view in his bedroom. A notebook recovered from the family home was recovered. It appeared to have been shared by all members of the household as it depicted Nazi symbols on one page and a grocery list on the other. He would regularly ask his parents when he could go shooting, and he bragged about how he had been asking for a 9mm handgun. A second notebook found, not hidden, but in plain view in the family home, depicted pictures of firearms on literally every page. So at this point, Judge, the evidence shows a 15-year-old who has repeatedly informed his parent that he was hallucinating. The same 15-year-old continuously demonstrated tendencies that were worrisome, all able to be found by his parents. He demonstrated one real passion in life, and that was firearms. His parents obviously know what had been directly told to them, but they did not intervene. They did not schedule therapy, did not investigate what might be in his room on his phone or his browser history. They didn't even keep their other weapons secured. And we know that because there was a video recovered from Ethan Crumbley's phone from August 2021 with him holding James Crumbley's .22 caliber Kel-Tec pistol in one hand, bullets in the magazine around in the chamber. He sent messages to a friend, "It's time to shoot up the school, JK, JK, JK. That was in August of 2021. The evidence will also show at the exam that Ethan Crumbley's one real friend, the one he sent that video to in August, left the state in late October. His parents knew that. They acknowledged the effect that it had on their son. And again, they failed to provide any type of intervention. Instead, they bought him what he desperately wanted, a 9mm 6-hour handgun. They bought that for him on November the 26th, 2021. And we know they bought it for him because we have the video from Acme Firearms that shows Ethan Crumbley standing next to James Crumbley. Then we also know that Ethan Crumbley posted a picture of him holding that firearm that same day, talking about his new firearm. He went shooting with his mother, Jennifer Crumbley, at another shooting range on November the 27th. She posted on her social media page about her shooting the firearm and about his new Christmas present. We know that Ethan Crumbley posted pictures of that firearm on YouTube. We know that he bragged about it to a friend. We have the video from the shooting range on November the 27th that clearly shows Ethan Crumbley was the one who knew how to manipulate and operate that firearm, and he showed Jennifer Crumbley how to do so. That evidence will be admitted at the examination. Even after they bought the gun, they could have secured it, but they failed to do so. They gave inconsistent statements about how the gun was secured. There were no statements made by either defendant that was actually locked up. All this was happening while Ethan Crumbley was planning to commit a mass murder. He wrote pages and pages about what he was going to do in his journal. He filmed a video of himself talking about what he was going to do. He shot that video at the family home. He stopped doing schoolwork and was surprised when his parents didn't seem to notice or care. And then we get to November the 29th, the day before the shooting. On that day, Ethan Crumbley is caught by his teacher looking up ammunition. Other students see him with shell casings and live rounds as well. His teacher immediately notified the appropriate parties within the school, who in turn met with Ethan, and they left a message for Jennifer Crumbley. She didn't answer the phone call, and she didn't respond to the voicemail that was left. Instead, she texted Ethan Crumbley, asking about what had happened. She asked him if he had shown them a picture of his gun, and she also said, "Next time, don't get caught." The next day, November the 30th, Ethan is caught by one teacher viewing violent videos that depicted a shooting. Another teacher observed that he drew what's been admitted as an exhibit in Peoples 1 and 2. Those teachers notified the dean of students and the counselor at the school. They took Ethan out of class and met with him. After reviewing the words written on the worksheet, those individuals formed the belief that Ethan was displaying suicidal ideation, and a risk assessment for suicide was performed. A decision was quickly made to notify Ethan's parents, these defendants, and to have an immediate meeting with both of them. When Jennifer Crumbley was called to the school, she first asked if they could call her husband instead. When she was informed that they tried to call her husband, but when he picked up, they only heard dead air, she then responded, "Well, I'll see if he can come to the school." Eventually, they both arrived together at the school. They're given the opportunity to view the worksheet that Ethan Crumbley drew what's been admitted as Exhibit 1 and 2, and they're told that immediate therapy is needed. Immediate as in that day. They resisted, instead asserting that they couldn't possibly take him out of school because of work. We have since learned that Jennifer Crumbley's employer would have gladly given her the day off, and she did not have any meetings scheduled until later in the day. As you have heard Prosecutor McDonald state, Judge, We also learned that James Crumbley was a DoorDash driver, giving him ample opportunity, to bring Ethan Crumbley with him. When they were given the drawing, neither one of them bothered to mention that the gun drawn by Ethan bore a striking resemblance to the gun they bought for him 4 days before. They never bothered to mention they didn't keep the gun in a gun safe, locked and secured. They also never bothered to mention that Ethan had displayed any of the troubling behavior that I had outlined. Instead, he said they couldn't take him home, and Jennifer's words to end the meeting were, "Are we done here?" This caused the counselor so much concern that he gave them a 48-hour deadline to call therapy, or to begin therapy, or he would call CPS. And that is the evidence that will be admitted when those witnesses testify at the preliminary examination. There's the timing is important as well. The defendants left the school at roughly 10:55 a.m. The shooting didn't begin until 12:51 p.m. The Crumbleys lived just down the road from Oxford High School. Even if for some reason they didn't want to tell the school about what they knew, they had ample opportunity to drive home, take 2 minutes to see if the gun was still there. They failed to do so. But when news of the shooting broke, each of them quickly concluded that their son was the one responsible. James went to his house and called 911, telling dispatcher that the gun was missing and his son might have done it. Jennifer texted Ethan and said, "Don't do it." She also texted a coworker that the gun was missing, and she was concerned that Ethan was responsible. Judge, this is a snapshot of the evidence that will be admitted on February the 8th and the ensuing dates for the preliminary examination. Search warrant returns are still coming in. We expect, based upon what we've seen so far, that the additional evidence will be inculpatory as well. I expect that the examination will lay out the facts and they give rise to these 4 charges. I expect this court will find probable cause to move this case on. At this juncture, I don't believe there is any reason why this court should amend the bond that was previously set. This court will have every opportunity to evaluate the facts and the evidence when presented at the appropriate time. I ask that these defendants' motion denied, Judge.
Thank you.
Your Honor, may I have a brief rebuttal? Just
Very brief, please.
Thank you, Your Honor. As the court is aware, shortly after the shooting on November 30th of 2021, the Crumbley's address, home address, was listed on the internet, and was also discussed on the record at their arraignment. Prior to being charged and arrested, they had received and been made aware of a plethora of threats to their lives and to their safety, and had to leave their home. The sale of their home has been necessary, as it is no longer a safe location for them to live, but it has nothing to do with a flight risk. Your Honor, further, and of importance, is the prosecution in this case is trying to avoid the fact that the defense repeatedly tried to contact them and to connect all day to make plans to turn our clients in on the charges that had been sworn to at noon that day. So, Your Honor, they were not trying to flee, Your Honor. They are not a flight risk. They were not a flight risk, and we're asking that the court grant our motion to reduce the bond.
Thank you. All right, we are here today for purposes of the defendant's motion to reduce bond. The court has had the opportunity to review the pleadings that were submitted by both parties, along with listening to oral argument today. I want to point out that the court rule that applies to this case is FCR 6.106. That court rule requires that the court set a bond that will assure the reasonably assure appearances of the defendant for all court hearings, and also reasonably assure any risk and or evaluation of risk to public safety. The factors that the court is to consider are all listed in subsection F of the court rule. Those factors, and they are not mutually exclusive, but those factors include prior criminal history. And in this case, the defendants did have a prior misdemeanor conviction in the state of Florida. Their record of appearances or non-appearances at court proceedings or flight to avoid prosecution. The defendant's history of substance abuse or addiction. The seriousness of the offense charged. The presence or absence of threats and the probability of conviction and likely sentence. The defendant's employment status and history, and financial history as the factors relate to the ability to post, and facts indicating that the defendant's ties to the community, including family ties and relationships, and length of residency. In this case, the court makes the following finding. that the defendants in this case have ties to the state of Florida. In fact, they did reside in the state of Florida, and as the prosecutor indicated, they still have family in the state of Florida. After the charges were issued, the defendants did not voluntarily turn themselves in. Instead, they were found in an abandoned building in the city of Detroit. Their vehicle was hidden to the extent that they were trying to avoid anybody being able to see their license plate. They withdrew a substantial amount of money from bank accounts, and they were not answering attorneys' calls. The seriousness of the charges, I think, is self-explanatory. They are each charged with 4 counts of involuntary manslaughter. So taking all those factors into consideration, the court finds that the bond as set is reasonable and is denying the motion to amend the bond. We will continue to the preliminary examination on February 8th, and at that point, the court will make a determination as to whether or not other days are necessary for purposes of conducting the preliminary examination. Before we disconnect, I do want to have a conversation with all attorneys in the breakout room. So, Amy, if you could please put the attorneys in the breakout room with me, please.
Thank you, Your Honor.
Thank you, Judge.
I tried that thing you do all the time. Praying. And it worked. Thank you.
We need to talk.
I know I've handled a lot of things badly.
And so have I, and that's why.
I really appreciate asking you to leave.
Okay, after the video, I'm trying to tell you. And
I hope you know.
see, Mel, ain't nobody say anything about sleeping with nobody, baby. I just kissed her.
Oh, you just kissed her, Joey. You look me in the face right now and tell me you didn't sleep with her.
Ellie.
Did you sleep with her, Derwin?
Good morning.
No. I wouldn't do that to you. Baby, I love you so much that I put a stop to it before it went too far. All right?
Okay.
I don't want to lose you. Boo. All right?
That better not be her. After party tomorrow. Need you in my jeans. Camille. Now it's Camille. Who's Camille, Darwin? Nico, I didn't stutter. Camille.
Hey,
On there?
hold up.
Who's Camille on there?
What's Camille there, boo? The after party boys wants to his clothes. The clothing line, baby. Come on. It's clothing line. Come on.
Camille. Look, Darwin. I guess we both made a lot of mistakes this year.
Yeah.
I'm sorry for sending you on a roller coaster with this engagement. I was just worried about losing myself in your life, that I didn't realize I was sending you a message that I didn't want to be in your life at all. I love you, Joe. That's why I want to marry you. And I want to be there for every bit of this ride. including tomorrow night. If that's okay with you.
You probably got to check with Camille. Anya? Not gonna leave me?
No. Not a word kiss. Mama didn't raise my phone.
Okay, we are back on. I was in a breakout room with all counsel. And at this point in time, we are going to proceed to the preliminary examination on February 8th. Any future dates that need to be scheduled will be addressed on that date and time. Additionally, after discussions with both counsel, or all counsel, I should say, the court will be expecting an amended order from the attorneys relative to the protective order in accordance with our conversations. Any questions on behalf of the prosecutor? Any questions on behalf of defense counsel?
No, Your Honor. No, thank you, Judge.
All right, you're all set. Thank you. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
This recognition is not about the Saints.